Child killer confesses in court to disturbing video game murder. You covered the youngster in waste bags and towels and tried to take him upstairs when you thought he was dead. Correct. A convicted killer describes how he beat his 5-year-old neighbor to death when he came over to play video games. The child whimpering started when you left the house. Was that also correct? Yes. When the child's whimpering began, you dropped a heavy cement flower pot on his head. When the killer confessed, the jury trial became a plea hearing. This case is for jury trial. However, the plea paperwork arrived this morning. Are you ready to plead guilty this morning? Yes. Mr. Poor, how do you plead to count 1, first-degree intentional homicide as a party to a crime? Guilty. Within 30 minutes, he was guilty of murder. I find you guilty of first-degree deliberate homicide. First, a law and crime legal alert. Masti Alliance, one of our legal sponsors, is assisting consumers fight for compensation because Google Incognito secretly collected their surfing data. Incognito.com lets you start your claim in less than 10 questions if you've utilized Google Incognito since 2016. ELC updates last October 25th in Milwaukee, Wisconsin. This case began. Prince McKee, 5, missed school on Wednesday due to a sore throat. His mom let him play video games downstairs during the day. She reported him missing to the police hours later after failing to find him. The next morning, his body was located a mile from where he was last seen. The investigation initially targeted 27-year-old David Poor. The basement unit of Prince's family housed him. This week, David Poor pleads guilty to Prince's murder. This case is for jury trial. However, the plea paperwork arrived this morning. Has the state followed victim rights notification law? We informed the family of today's date, proceedings, and plea talks. They should arrive at court soon, I believe. On the morning of the murder inquiry, Police K9 smelled decomposition and found blood in Poor's residence. He first denied involvement. He told investigators he walked to the park the day Prince disappeared, but his phone's GPS tracker revealed otherwise. Police detained Poor for obstruction. In exchange for his guilty plea, prosecutors dropped his lower counts. What is the offer that the state has made to Mr. Poor to resolve this matter? The state wants Mr. Poor to plead guilty to 1 first-degree intentional homicide. The state would ask the court to dismiss and read in counts 2 and 3 at sentencing in exchange for that guilty plea acknowledgement. Parties can freely argue for the right wording. The state can seek life without parole. Eventually, the truth emerged. Prince played video games at Poor's house the day he disappeared. The facility also housed then 15-year-old Eric Mendoza. Poor told authorities he exited the room and found Mendoza choking the youngster. He later told investigators they choked and fist-beaten Prince. Mendoza hit the youngster with a golf club and barbell. Poor's sentencing hearing covered these grisly details. As a criminal, you killed Prince McKee, born December 23, 2017, who was another human to kill that person. This case began on Wednesday, October 25, 2023, at 2411 North 54th Street in Milwaukee, Wisconsin. It appears Prince McKee went missing that day. Police searched for 5-year-old Prince. It appears you resided in his parents' basement with him and his brothers. That right? Yes. Prince's mother kept him home from school on October 25, 2023. He was sick with a sore throat and cough. That also true? Yes. He disappeared, prompting police to investigate. Officers initially found blood in your North 54th Street basement. That right? Yes. You and co-actor Mr. Mendoza played video games down there earlier in the day with Prince. That right? Yes. You watched the child, and unfortunately, it irritated Mr. Mendoza. That right? Yes. Mr. Mendoza pummeled this poor youngster. That right? That is correct. He initially whacked this unfortunate boy with a golf club. That right? Yes. You feared the boy was dying, so you and Mr. Mendoza duct-taped his arms. That right? Yes. Poor and Mendoza put Prince in duct tape and garbage bags. They were caught on camera near a dumpster where the boy's body was found. You tried to wipe up the blood using towels and other items. That right? Yes. Of course, you covered the youngster in waste bags and towels and tried to remove him upstairs out of the house when you thought he was dead. That right? Yes. The youngster started whimpering when you left the house. Was that correct too? Yes. When the child whimpering began, you dropped a heavy cement flower pot on his head. That right? That's not correct. What happened? It was Mr. Mendoza who did that. Ok, you didn't stop Mendoza. That right? No. You also acknowledged hitting the child to the police. True. Yes. All of these actions led to his death, including your police confession that you got a barbell from the bedroom and dropped it on the boy. That right. Mr. Mendoza did that as well, so that's not true. Even though that's what you told the police in an interview with them on October 27th of 2023. Me and Mr. Mendoza accomplished that, not simply myself lifted the barbell. Ok, fair enough. Mr. Mendoza and you dropped the barbell on this child. That right. He did it once, and then I did it once. And the flower pot? Both of you and he did it once. Yes. Ok, Prince McKee died because of your and Mr. Mendoza's intentional acts. That right. That is correct. You and Mr. Mendoza discarded the body in a dumpster near a restaurant. True. That is correct. Ok, I think that's true. For the plea, is it enough for the state? Yes. Pure and Mendoza were accused of Prince's murder. Mendoza is charged as an adult despite being 15 when the boy died. Pure said he understood his plea and lost rights at his sentencing hearing last week. Let's discuss rights. Do you realize that by pleading guilty now, you are giving up your right to a trial? Yes. Do you further understand you are giving up your right to remain silent, that your silence could not be used against you at trial? Yes. In addition, sir, you're giving up the right to testify and present evidence at trial. Do you comprehend? Yes. You also relinquish your ability to subpoena witnesses to testify at trial. Do you comprehend? Yes. Also, Mr. Pure, you're giving up your jury trial right. 12 community members would serve on this case's jury. In voir dire, the state, your lawyer, and you choose the jury. The jury would sit in the jury box after selection. After hearing all the evidence, the jurors must agree that the state met their burden of proof on every aspect of the offense before finding you guilty. That won't happen without a jury. Do you grasp that? Yes. Sir, you also relinquish your right to face your accusers in court. These are state witnesses. If we had a trial, Attorney Jones would cross-examine or question state witnesses for you. That won't happen either. Do you comprehend? Yes. Lastly, sir, you're giving up your right to a fair trial. Do you comprehend? Yes. Mr. Pure, are you giving up every one of the constitutional rights that you may just talked about here in open court today of your own free will? Yes. Pure also knew his sentencing would be the harshest. On or about Wednesday, October 25, 2023, at 2411 North 54th Street in Milwaukee County, Wisconsin, you caused the death of Prince McKee, born on December 23, 2017, who was another human with a purpose to kill that person. This violated Wisconsin statutes 939.50 to 3, 939.05, and 940.01 to 1. Sir, do you comprehend? Yes. Your class punishment, a felony, is life in prison. Do you comprehend? Yes. Your sentence's overall length. After 20 years, you could be released to extended supervision. You may be released at a date and time I choose or not eligible for extended monitoring. Understand those penalties? Yes. Knowing all that information, Mr. Pure, how do you plead to count 1, first-degree intentional homicide as a party to a crime? Guilty. The judge then considered Pure's sentencing. Do you understand that I will carefully consider state arguments at sentencing? I will listen to victim impact statements from the victim's relatives. Then, I'll carefully listen to Attorney Jones' arguments for you. Finally, I will listen to your speech. Do you comprehend? Yes. Despite the lawyer's good sentencing arguments, and your and everyone else's good statements, it is still up to me, the court, to decide the sentence in this case. I could consider life without parole, the maximum legal penalty. Do you comprehend? Yes. So Pure's guilty plea was accepted. The court concludes that Mr. Pure is pleading guilty today. Freely, voluntarily, intelligently, and knowingly. Mr. Pure knows the crime and its elements. He knows each element's supporting facts. He knows he's waiving all his constitutional rights by pleading guilty today. Finally, if convicted, he knows his maximum penalty. Mr. Pure, I accept your guilty plea and find you guilty of count 1, first-degree intentional homicide as a party to a crime in Milwaukee County Case Number 23 CF 4961. I convict you of this offense today and order it recorded into the record. Mr. Poor, the state stated at the start that they would move to dismiss count 1, but read in counts 2 and 3 after your guilty plea. That implies I can still consider child physical abuse, repeated acts causing death, and hiding a corpse at sentence. However, I cannot increase your sentence for those counts. You may be compelled to make restitution, but the charges are being dismissed and read in, and cannot be brought against you again. Sir, do you comprehend having the charges dismissed and read in? Yes. Do you consent to the court granting the state's motion to do so? Poor will learn his fate in court on July 26. The hearing will feature him and Prince's relatives. Sarah Gillespie, law and crime reporter. Did you like it? Tell us what you think of the video in the comments section below. And don't forget to subscribe to our YouTube channel for more interesting videos.